Major breaking news. The lawyers for Bryan Range have submitted a powerful brief opposing the Department of Justice of Kamala Harris and Merrick Garland, who, as you know, are trying to uphold the constitutionality of 18 U.S.C. 922 G1 to argue that nonviolent felons can be banned from touching guns, possessing guns for the rest of their lives. Major arguments against the Department of Justice position have just been filed in the United States Court of Appeals for the Third Circuit, and we're going to break it down for you when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon, and if you've already read it, please feel free to leave a review on Amazon. I always enjoy reading those. I learn a lot from them. And again, I will be at the Gun Owners of America event in Tennessee signing books and giving presentations. So if you're going to be down there in Tennessee for the Gun Owners of America event in a couple weeks, make sure you stop by and say hello. All right, folks, so here's the story. The attorneys for Bryan Range in the Range versus Merrick Garland case dealing with the constitutionality of 18 U.S.C. 922 G1 dealing with felons in possession and whether or not a nonviolent felon like a Martha Stewart type can be disarmed for life under the Constitution, under the Second Amendment, is in full swing. As you may recall, the U.S. Court of Appeals for the Third Circuit, which is the Court of Appeals that covers Delaware, Pennsylvania, and New Jersey, found that Bryan Range could not be disarmed for the rest of his life for a 30-year-old conviction for a misdemeanor of some sort of food stamp, failing to disclose information associated with food stamp application. But it was technically a felony as defined by federal law because he could have gone to prison for multiple years. But of course, he never served a day in prison. But nevertheless, under federal law, he lost his right to keep and bear arms. The Third Circuit en banc issued a ruling that says that that was unconstitutional as applied to Bryan Range. And the Department of Justice took a cert petition to the U.S. Supreme Court, and the Supreme Court decided the Rahimi case, and then they GVR'd, meaning they granted cert, vacated the Third Circuit decision, and sent it back down for further consideration. After that, the Third Circuit issued a request to the attorneys saying, please send us a brief. Each of you send a brief or arguments explaining whether or not the Rahimi case makes a difference on our decision in the Range case, so we decide whether or not we want to reissue it or not. It's pretty clear, in my opinion, that the Rahimi case by the U.S. Supreme Court does absolutely nothing to the question of whether or not Bryan Range can be disarmed under the Second Amendment. If anything, the Rahimi decision actually strengthens the argument that nonviolent felons such as Bryan Range cannot be disarmed for life because, again, the decision of Rahimi was that an individual that was clearly violent and admitted to violence and was a clear, credible threat to a third party, a violent physical threat to a third party, could be disarmed temporarily. And now the attorneys for Bryan Range have filed a powerful brief explaining exactly some of the arguments we've talked about on this channel about why the Rahimi case is not bad for the right to keep and bear arms. If anything, it has essentially expanded it and will be used by people like Bryan Range and other nonviolent felons to ultimately get their Second Amendment rights back, is my prediction. So let's turn and see what the brief specifically says. To begin, let's see what they say right at the beginning. In United States versus Rahimi, the Supreme Court concluded only this: an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed, consistent with the Second Amendment. On its face, Rahimi's holding does not apply to Bryan Range. Indeed, Range's case is, in many ways, the opposite of Rahimi. Rahimi was a facial challenge to Section 922 G8. Range challenges Section 922 G1 only as applied to himself. The Rahimi decision involved an extensive recent history of violent behavior that culminated in a court specifically finding that Rahimi posed a danger of physical violence to others. The government has expressly admitted here that Range has never engaged in violence, nor has he ever threatened anyone with violence. And of course, it goes on that the only argument against Mr. Range here was that he made false statements on a food stamp application 30 years ago, which has nothing to do with physical violence. So the lawyers go on to point out that it actually turns out that the decision by Rahimi in the Rahimi case is entirely supportive of Range. Remember how I told you the Rahimi case is going to be used as a weapon of offense by Second Amendment lawyers. Here's another example of this. They write that it is entirely, meaning the Rahimi decision is entirely supportive of Range and reinforces the Third Circuit's en banc majority's conclusion that Mr. Range cannot be permanently denied the right to possess firearms for lawful purposes based merely on a 30-year-old non-violent conviction. That is entirely correct in my view, and I think the U.S. Supreme Court will agree with that. By the way, the lawyers for Mr. Range go on and argue that another way that the Rahimi case supports the argument is that in the dissenting, there were dissents in the Third Circuit decision, right? The Third Circuit came out and said Mr. Range cannot be denied his right to keep and bear arms for a nonviolent felony conviction. But there were dissents there by certain judges that said, oh yeah, he can be disarmed for the rest of his life by virtue of this nonviolent felony. But the rationale of those dissents in many respects has been blown up by the Rahimi decision, again showing us that Rahimi is good for us. Because what happens is, if you look at the dissents against Mr. Range, they argue that Mr. Range has demonstrated that he is not a law-abiding, responsible person. And what did the U.S. Supreme Court say about that argument? In Rahimi, they specifically, 9-0, by the way, it was the 8 justices in the majority plus Clarence Thomas in the dissent, all 9 of them agreed on this one point, which is that just because someone is not responsible is not a basis to disarm them even for a minute. That's not the standard. As I taught you before the Rahimi decision was ever decided, that in my view, the Supreme Court was going to say that the only people that can be disarmed are those who are physically violent dangers to others, and maybe down the road, physically violent dangers to themselves via a suicide risk. But the reality is this has nothing to do with Bryan Range, who, as even the government and Merrick Garland have admitted, is not violent in any respect and has never threatened violence toward anybody at any point in time. Now, then the brief for Bryan Range does a very nice job laying out what we've talked about all the time. Very important to understand this. The Heller-Bruen methodology of interpreting Second Amendment cases or applying the Second Amendment, you start with the text of the Second Amendment, the right of the people to keep and bear arms. Now, in the case of Bryan Range, the critical word is Bryan Range, as an American citizen, part of the people? The answer is obviously yes, because in the Heller case, the Supreme Court said that anybody who is connected to our national community, reasonably connected to the national community, is a part of the people, as in the right of the people to keep and bear arms. Because Mr. Range is an American citizen, he's part of the people, and textually denying him the ability to keep, which means to possess, or to bear, which means to carry in public, arms, obviously is an infringement textually of his right to keep and bear arms. And as a consequence, as the lawyers for Mr. Range say, that means the burden shifts to the government, and that's exactly what Chief Justice John Roberts wrote in the majority opinion in Rahimi, that specifically they focused their entire decision essentially on the historical tradition of firearm regulations part of the Bruen text, then burden shifting, then historical tradition analysis. And the Rahimi case was all about, was there a historical tradition of some sort of firearm regulation that would deny the ability or would allow government to disarm certain people if they demonstrate to be a violent threat with firearms. And as you know, there were 2 types of laws that the court identified that were long-standing, so long-standing that they were discussed even by William Blackstone and Blackstone's commentaries. One was the Surety laws, which is a form of preventative justice that says that if someone posed a violent risk to someone else after a trial established that, then you could either force them to post a bond or to be imprisoned. So that was the Surety laws. They said, well, that's because if you are found to be a violent danger to someone, there's certain recourse that the government can take against you to potentially put you in prison or force you to post a bond. Likewise, there were criminal statutes that also punished people for misusing firearms or misusing weapons. Those were known as the affray laws or going arm laws. And again, the Supreme Court basically said that in light of the existence of both the Surety laws, preventative justice laws, as well as the going armed or affray laws, criminal laws, where you can be punished for misbehaving with a firearm or weapon, guess what? That gave rise to a historical tradition of saying that if you are found by a court, after due process, to be a violent threat to somebody else, a credible violent threat to someone else, you can be temporarily disarmed. Now, of course, the lawyers for Bryan Range make a powerful point here, which is correct. It says, how is it possible that the government is trying to use the fact that Mr. Rahimi was a total violent thug based on the record, involved in no fewer than 5 different shootings, plus taking his girlfriend's head and hitting it against the dashboard and shooting at a potential witness that saw it. And he admitted to all of this in court and admitted and agreed to the entry of a restraining order. How is that anywhere analogous to Mr. Bryan Range, who 30 years ago had a food stamp-related line on a form that has nothing to do with violence whatsoever, and yet the government is trying to say that the Rahimi case involving this violent thug somehow justifies taking away guns from non-violent Bryan Range? That's utterly BS, and there's nothing about the surety laws or going arm laws that the Supreme Court found to be a sufficient historical tradition analog laws. There's nothing about those, of course, that speak to non-violent felons, and that's exactly what the lawyers for Mr. Range argued here. Now, the last point I want to bring up is a discussion that we've had before about the argument that the anti-gunners and some of the anti-gun judges in the Range case argued in dissent against Mr. Range. They said that because at the time of the founding there were certain crimes that you could be sentenced to death, meaning put to death, and therefore, in light of that, those can be analogous laws because we're not trying to put Mr. Range to death, we're simply trying to disarm him. And the argument is essentially, because we had, at the founding era, the ability to put you to death with the death sentence for these kinds of crimes, at a minimum, we're able to disarm you, which is a much lesser type of punishment, obviously. But that is addressed specifically, and we talked about why this is not true. It's the difference is that the Rahimi, the Supreme Court, is very focused on, are you a violent danger with a firearm? Are you at risk of misusing a firearm? It's not just a general notion that you're somehow misbehaved, and at the time of the founding you could be put to death for that. No, it's a specific, they're looking for a historical tradition of firearm regulation. You hear what I just said? A historical tradition of some sort of firearm-related regulation, not just sort of gestalt of some sort of criminal laws or anything like that. They're looking for things that are specific to firearms or weapons or something like that, and that is simply not on the books here. And I think the lawyers for Bryan Range did a good job. Let me illustrate what they said here. The Third Circuit majority rejected the government's argument that because founding-era practice was to punish some felony offenses with death, it must therefore be appropriate to disarm modern felons who are not put to death for the rest of their life. As the majority in the Range case explained, the greater does not necessarily include the lesser. Founding-era government's execution of some individuals convicted of certain offenses does not mean that the state, i.e. the government, then or now, could constitutionally strip a felon of his right to possess arms if he was not executed. Now here, of course, Range's offense was a misdemeanor, so this argument does not even apply to him. Again, as you see, there's an attempt by the anti-gunners to try to say that if we could put you to death for any reason at the time of the founding, we can disarm you today. But that doesn't line up with the how and the why, meaning why were these laws enacted at the time of the founding and how are they enforced, and does that line up with the modern day gun control related law? Again, there is nothing on at the time of the founding, by the way, that would indicate the misdemeanor, the state misdemeanor, nonviolent. Remember, Bryan Range was convicted of a state misdemeanor, but because the statute under which he pled guilty to allowed, in theory, that he could go to prison for multiple years, under the federal statute, 18 U.S.C. 922 G1, it technically qualified as a felony as defined by that federal gun control statute. Nevertheless, under state law, it's nothing more than a misdemeanor, and he never served a day in prison. So here is the other rebuttal that Bryan Range's attorneys raised about this. Despite a superficial similarity, the greater includes the lesser argument engaged in by the dissent, i.e. the anti-gun dissent, is entirely unmoored from the guidepost of the comparison between how and why historical and modern statutes restrict the right that were critical to Rahimi's reasoning. It is instead predicated on the idea, entirely foreign to any historical restriction on the right to keep and bear arms, cited by the government or the dissents in the Range case, that lifetime deprivation of Range's constitutional right to own firearms is a justifiable punitive measure, excused by the state's forbearance in not simply executing him for the failure to properly report lawn mowing income when applying for benefits. Powerful stuff there. Again, it goes back to the way to understand this as I see it is that because the Supreme Court in a Second Amendment case is looking for a long-standing tradition of some sort of firearm regulation, just because you can find some kind of random law at the time of the founding that you in theory could be put to death, that is not necessarily a historical tradition of a firearm-related regulation. And I think that's the key. Because both the surety laws and the affray laws talked about in the Rahimi case both spoke to the potential or the actual misuse of a weapon or an arm. And that is key. It all has to go back to somehow connecting up with some sort of misuse of an arm and not some open-ended thing that you can find any kind of a law that speaks to something that was a criminal law where someone could be sentenced to death, and that somehow is a sufficient analogous law to justify it under modern-day Second Amendment jurisprudence. That is simply not the case. And I think that's the point that the lawyers for Bryan Range were making here. And we will see what happens, of course, because the U.S. Court of Appeals for the Third Circuit is going to have to rule on this. Here's what I think is going to happen. This is my best prediction. I do not think there will be oral argument. I think there will be a decision in the next 45 days or so by the U.S. Court of Appeals for the Third Circuit. It will reaffirm and confirm its prior decision in the Range case. And I think what may actually happen is some of the dissenting judges in the Range case may actually come over and join the majority of that en banc ruling in favor of Mr. Range. And some of the dissenters may say, we previously dissented before Rahimi. In light of the Rahimi ruling, we now agree that the majority of the Third Circuit got it right. So again, but at the end of the day, I don't think any judge that was in the majority in favor of Bryan Range in that en banc Third Circuit decision is going to switch over and dissent or come out a different way. I think some of the dissenters may join and reaffirm that Mr. Range should not be disarmed permanently. And then after that, Merrick Garland and the Kamala Harris Department of Justice, presumably, or I should say the Joe Biden Kamala Harris Department of Justice would seek cert from the U.S. Supreme Court. But again, if Donald Trump wins the White House and becomes the president in January, then you'll have a new group of people running the Department of Justice, a new Solicitor General, a new Attorney General, and they may have the ability to support Bryan Range in their argument to the U.S. Supreme Court. And they may be able to come out and say, we agree with Bryan Range that this is unconstitutional under the Supreme Court precedent. It is not impossible for the Department of Justice to take that kind of a position, but that's only going to potentially occur if you get a President Trump, and of course you get the appropriate lawyers in that administration to make this argument. And I don't think that's impossible. I think what I just described is something that could definitely occur. Again, it's all going to turn on who wins in November, and we won't know that for a few months. So we'll go from there. Okay, folks, hope you learned something here today. Make sure you follow me on X if you're not already doing so. I tweet out a lot more stuff than I can cover here on the channel. Political issues, social issues, cultural issues, and of course, a lot of Second Amendment related stuff. So make sure you follow me on X at 4 Boxes Diner. Don't forget to subscribe to this channel, and we'll see you again soon enough, the 4 Boxes Diner.
Orders up. Table 2A.